The statute of fraud says that certain kinds of contracts are generally unenforceable unless the terms are set forth in a writing signed by the party to be charged or the one against whom enforcement is sought. This includes contracts for the sale of land. The Washington Court of Appeals considered whether an alleged contract for the sale of building lots either satisfied the writing requirement or fell under something called the part performance exception in Wagers v. Associated Mortgage Investors. In the spring of 1975, Robert Wagers entered into negotiations to purchase 104 building lots from Associated Mortgage Investors, or AMI. Eventually, Wagers signed an earnest money agreement, which stated that he was willing to purchase all of the lots for $250,000 and mailed it to AMI. During a phone call, AMI informed Wagers that its board of trustees had approved the sale for a modified purchase price of $270,000. However, there were still some problems with clearing title. After the phone call, the attorneys for AMI and Wagers exchanged a series of letters. The first letter from AMI's attorney stated that the proposed sale to Wagers was still subject to board approval and resolution of the problems with clearing title. The second letter from Wagers' attorney confirmed that the lots had been sold to Wagers and indicated that Wagers was in the process of obtaining financing in reliance on the sale. The final letter from AMI's attorney emphasized that board approval was actually still pending and that the property had not yet been sold to Wagers. The sale never happened, and Wagers sued AMI in Washington State Court for specific performance of the sale, or, in the alternative, damages for breach of contract. AMI raised the statute of frauds as a defense, and the trial court entered summary judgment for AMI. Wagers appealed to the Washington Court of Appeals.